Welcome to your first Federalism and the Missouri Constitution video. Let's get to it. Our learning target for this section is going to be to describe the changing relationship between the federal government and the state government. So let's do it. First of all, federalism, we know, is a system of government in which power is divided between states or regional governments and a central government, aka what we have in the United States with our division between the United States federal government, state governments, and regional governments that we have. So federalism is reflected in the Constitution in a few different ways. First, we have specific powers that are given to the national government. So think of an example for that, something that only the national government can do. We also have powers that are given only to the states, so something only state governments can do. We also have powers that are prohibited, that neither the state or the federal government can do. And then we have powers that are shared, meaning that there's something that each of the types of government or the levels of government can do. So I want you to pause right here, think for just a couple of seconds about some examples, and whatever you can't think of, we'll get to in class. So powers of the national government, they are specifically stated in Article 1, Section 8 of the Constitution. And these are what we call the enumerated or expressed powers of Congress because they are specifically numbered in the Constitution. And we know that the elastic clause, which is also called the necessary and proper clause, gives Congress the power to make any law that they think is necessary and proper. And we say that it's the elastic clause because that clause stretches the power of Congress. It doesn't tell Congress what necessary and proper is and what necessary and proper isn't. So it expands their power. We also have the supremacy clause, which can be found in Article 6 of the Constitution. And that one deals specifically with supremacy of national law, meaning if there's ever a conflict or if there's ever a question between which law is supreme, federal or state, it's always going to be federal, okay? Don't worry about McCulloch v. Maryland. We'll talk about that in class. So in the Constitution, we also have specific sections that deal with powers that the state governments have. So we know that the 10th Amendment is the States' Rights Amendment, and it gives the states any power that isn't specifically given to the federal government and not denied to the states. So the 10th Amendment is the one that protects those reserved powers. So things that the federal government can't do or doesn't do are reserved for the states. States also have what are called police powers. And police powers are kind of like the necessary and proper clause, meaning that they have the authority, states have the authority to create any law within their state that's going to promote the general welfare, safety, health, etc. of the people that live in it. So the states have the responsibility to make laws that are going to help the people in their state. We also have concurrent powers, and these are things that both the federal government and the state government can do within their jurisdiction. So if you think about this as like a Venn diagram, the concurrent powers are going to be the ones that are in between, okay? So concurrent powers include the ability to tax within their jurisdiction. So you have state taxes and you have federal taxes. The ability to create courts within their jurisdiction. So you have federal courts like the Supreme Court that we talked about, and then you have state level courts that deal specifically with state level issues. And they also have the power to pass and enforce laws, again, within their jurisdiction. So we have federal laws and we also have state laws, okay? And with that, I'm going to stop. If you guys have any questions, let me know.